Before I move on to ground 5, can I just answer Your Lordship's query about the citation, if any, of Van der Dungen since that decision was made? I'm grateful to my two juniors for the research they've done over the short German. Their research has disclosed that it's been referred to in 3 subsequent cases. Firstly, a case called Berladir, B-E-R-L-A-D-I-R, against Russia, decided in 2012 in the European Court of Human Rights. That concerned Article 11, an anti-fascist march planned somewhere in Russia, and the protesters were told that they had to hold the march in a different place, and it was cited in a dissenting judgment in relation to Article 11 and was used to support the proposition that requiring a person to change the location of a protest can be an interference with Article 11. Secondly, in another Strasbourg case, CSERJES against Hungary, decided in 2001. Article 9 does not protect every act in the public sphere which is dictated by religious conviction. And another way of expressing the point that is made in the Van der Dungen case, and which I think the court saw made in the later Article 9 cases that I showed you before the short adjournment. And then finally, in a case which is in the joint bundle of authorities, behind tab 7, called Van Schimel. Yes. And if you go to page 44 of the bundle, the first of the sidelined paragraphs, the Commission is the same point.
This is the European Commission.
This is another quite old European Commission decision, 1997, and it's an admissibility decision as well. And the Commission further recalls that Article 9 does not always guarantee the right to behave in the public sphere in a way which is dictated by a belief. The term practice of the Convention does not cover each act which is motivated or influenced by a religion or belief, CF, and that is a reference to the case number of the Van der Dungen case, as one can see by looking back to page 37. If any further citations come to light overnight, I'll let you help them in the morning, but I think they're confident between them that they've covered all the bases.
Thank you.
So, on ground 5, we say the judge failed to consider whether the order could have been formulated in a less restrictive way. And can I take you back to the judgment and ask you to go first to page 131 of the court bundle, paragraph 77. Now, this paragraph 77 was the first paragraph in a section entitled Section 59.5 and Less Restrictive Alternatives. But in fact, what the judge addressed in this section was not the question whether the order could have been made in a less restrictive way, but whether there were other provisions or measures, for example, the Protection of Harassment Act, that could have been used instead. So that isn't relevant for present purposes. And then, beginning at paragraph 85, under the heading "The Terms of the PSPO," the judge noted in the opening sentence of paragraph 85, the claimants criticised the breadth of the PSPO, as indeed they did below. But what he then went on to consider were a number of specific points that were made by the claimants as they were below. In addition, but the claimants below also, the appellants below also made the further point that the order was much too broad in any event, and that it could have been and should have been much more targeted. One can see that from paragraph 62 of the skeleton below. I'm not suggesting you turn it up, but if you'd like a page reference,
Yes, please.
it's page 164 of the same bundle, paragraph 62 and following. But even at paragraph 87, when he not invite you to read.
I mean, don't. You're taking 5 and 6 separately.
Yes, I am.
But aren't 5 and 6 all part of this proportionality exercise?
No, because in 5 we're going to look at the terms of the order in a moment, and I wish to make some submissions about how they are much too broad, and they don't adequately specify what it is that they seek to prohibit or restrict. And then 6 is the broader question and the separate question as to whether the judge gave sufficient weight to the Article 9, Article 10 and Article 11 rights of the appellants. Now, of course there is some overlap to the extent that the prohibitions in the order must reflect whatever the judge had decided in relation to the balancing exercise. But essentially, it's a freestanding exercise. It could, because it's I think accepted on all sides, that any interference, one of the conditions of interfering with any of the rights under Articles 9, 10, and 11 is that the interference is the least restrictive, as is reasonably possible.
Yes.
And that's what this ground is addressed to. And I hope to show by reference to
This is the least possible restrictive. This is, I think, and the fall in proportionality exercise is the last one.
correct. Right. And so in my submission on analysis, they are separate grounds. So in a minute, I'm going to actually pick up Liberty's skeleton, because they deal with this in a way which we think is very helpful, by reference to each of the prohibitions or restrictions set out in the order, and just make the submissions that essentially they make as to why those, most not all, but most of those restrictions or prohibitions are much too broad, and as a result it's impossible for the protesters, in inverted commas, to know exactly what it is that they are or are not able to do. But at the moment I'm just seeking to demonstrate to the court that the judge never addressed that particular issue. He didn't address it in the previous section, nor does he address it in this section. He says, paragraph 87, a number of objections are taken by the claimants to the actual wording of the terms of the PSPO, but what he then goes on to address is not the question whether the PSPO could have been drafted in a less restrictive way, because he doesn't address that question at all.
Right.
We submit that he should have done so, but particularly in a case which is firstly interfering with convention rights, and secondly potentially criminalises otherwise unlawful conduct by making it an offence to breach the order. So self-evidently the order needs to go no further than is necessary, and needs to be clear and precise about what it is that the protesters may be at risk of criminal prosecution for.
I'll see how 5 and 6 meld together.
Can I, for this purpose, then take you to the order itself, which is at the back of the core bundle behind tab 17, beginning at page 227. Now, paragraph 4 sets out the activities prohibited in the zone around the safe zone around the centre. In other words, the area where the appellants had been protesting or taking part in the vigils. But it also provides some restrictions which apply to the designated area, which is the area which has been designated by the council for such activities. And before I get to the detail of paragraph 4 and the specific activities which paragraph 4 prohibits, can I just invite you just to compare paragraph 4, just by, as it were, glancing for the time being through the activities as they're set out, with the much more targeted restrictions that apply in the designated area as set out in paragraphs 11 to 14. So, if, for example, the concern was with the number of persons taking part outside the centre, then a much more targeted restriction or prohibition could have been made. See paragraph 11 of the order in relation to the designated area.
You need to do this quite carefully. Is that your first submission?
No, my first submission is if one compares, is to invite you to compare the two in general terms, so that you see that it was entirely possible for the respondent to provide much more targeted restrictions than those set out in paragraph 4, which applied to the safe zone. So if their concerns had been with, let's take the question of pictures or texts or the like. If you compare 4(5), top of page 228, displaying any text or images relating directly or indirectly to the termination of pregnancy on the one hand, with paragraph 12 at 229 on the other hand, one can see that it was perfectly feasible for the respondent to draft a much more targeted restriction. No individual post of text or image, singly or collectively greater than one sheet of A3 paper may be displayed within the designated area. That's just a general, almost introductory point, so that the court has an understanding of the striking contrast between the very broad prohibitions contained in paragraph 4 and the much more targeted prohibitions contained in relation to the designated area, and the point that it was entirely feasible for the council to provide much more targeted prohibitions. Now, with that general point in mind, can I invite you to pick up Liberty's written submissions and to go to page 13. where in paragraph 20 they say that the central error in their submission, in the judge's analysis, was a failure to assess the proportionality of the restriction imposed by the PSPO, not only cumulatively but also individually. And then they set out the well-known structured approach, and then over the page at paragraph 22 and following, they address each of the restrictions or prohibitions in turn. And the first that they address, and if you have the order itself open, still open, at the foot of page 227, it is the prohibition of protesting, namely engaging in any act of approval stroke disapproval or attempted act of approval stroke disapproval with respect to issues related to abortion services by any means. This includes, but is not limited to, graphic, verbal or written means, prayer or counselling. And can I just read you what Liberty say in paragraph 23 of their written submissions, because we couldn't put the point any better. This provision of the PSPO imposes an extremely broad prohibition on protest activity within the safe zone. It captures all activity relating to abortion services which carries with it approval or disapproval. Such activity does not need to be offensive or shocking, still less intimidating or harassing. It simply needs to express a viewpoint on abortion. The prescription appears to include, for example, a silent prayer vigil or the silent display of a sign saying, "Please reconsider," or merely standing whilst wearing a pro-life or indeed pro-choice badge. This element of the PSPO thus captures the full gamut of opinionated activity, including the most unobtrusive, factual and mild-mannered expression of a viewpoint. And as I say, we respectfully agree with and adopt that submission. It goes way, way beyond what could conceivably be thought to be justified. What the judge didn't do was to consider whether that prohibition, not only did he not consider whether it was justified, because he didn't consider the question of justification at all, but he didn't consider whether what the council was seeking to achieve could have been achieved in a less restrictive way. I mean, that is essentially a blanket ban by any other name. Now, Liberty also go on in their written submissions to consider the other components of the Article 9, 10, 11 exercise, because in paragraph 24 they raise the question whether the respondent has identified a legitimate aim, and that is subject to your Lordship's and your Ladyship's views on our third ground of appeal, that I take as read. But the second question at paragraph 25 is that they raise is whether there's a rational connection between such a blanket ban on any form of display of approval or disapproval and the legitimate aim in question. And they submit that, seen in that light, the scope of the prescription is so broad as to lose any rational connection with the aim, not least because it captures or could capture any activity some of which couldn't possibly be connected to the aim pursued. So here there is some overlap with my lord's, with the ground 6, but I take it now because it's convenient to do so, since it's set out in Liberty's submissions, and because when I come to ground 6, I'm going to be looking at the generality of the balancing exercise rather than the specific balancing exercise which needs to be carried out in relation to each of the prohibitions.
It's a yes, because I would have thought that what one might have done when you getting to this stage, one might have said, well, looking at the proportionality exercise, taking into account the Article 8 rights, which we are, for this purpose, assuming are engaged, Article 10, Article 9, Article 10 and Article 11, which we're assuming are engaged. The first question you'd say is, well, should there be, in weighing it up, should there be any order at all?
Correct.
And then you'd go on to say, which is already, that's really Article 6, not your ground 6, but I would then say Article 5, assume that there should be some restriction on the Article 9, 10, 11 grounds. Then you go through the proportionality exercise at that point, but you're not doing it that way.
No, I'm sorry, I'm doing it the other way around.
Yes.
It's not terribly helpful, but because our 5th ground is addressed to the failure of the judge to consider the less restrictive point.
Am I right in thinking that
yes,
would be a legitimate
that would be the logical,
an analytically sound way of doing it?
That would be the logical way of doing it.
Okay.
Yes. Another reason I'm not doing it that way around is because we think it more helpful to leave to the very end of our submissions what we have to say about the evidence in the case and the justification in terms of the evidence for the interference with the Article 9, 10 and 11 rights. I hope it's not too unhelpful to be doing it this way around, but...
No, it's fine. I just wanted to make sure that I hadn't analysed it correctly.
Your Lordship's analysis is entirely correct. And then Liberty go on to consider in paragraph 26 whether, as part of the proportionality assessment, it's really the same point, there's an available less intrusive measure which wouldn't compromise the objective, and that's the less restrictive point in another form. And then in paragraph 27, the proportionality exercise, where they say that such an overbroad prescription does not strike a fair balance between the competing rights, bearing in mind that this is a blanket ban. And then on page 16 there's some reference to authority. Those cases are in their bundle, and it may assist my Lord and my Ladies if I just tell you where they're to be found. Under little a, that case is tab 3 of their bundle. Little b, the Sanchez case, tab 21, and the Animal Defenders case, tab 22. So we submit that the first prohibition is unreasonably and unjustifiably broad, and that what the judge should have done was to consider whether some less restrictive and better targeted prohibition that actually addressed the concerns of the council could and indeed should have been imposed.
Assuming, I know you're going to go through each of these different limbs of the order, but let's assume, taking your first point, assuming you're right on that,
Yes.
For argument's sake, I'm not deciding it now, but if you're right on that, does that mean that this court would then have to form its own view?
No, my Lord. Your Lordship will remember that under the Act, the section I showed you, setting up the court's powers on a challenge to an order, include the power to quash one of the prohibitions or restrictions. So we say that this court should quash the first of those prohibitions, and then the council will have to reconsider what prohibition to make in the light of what this court has said about the excessive breadth and so on of the prohibition.
Right, okay, thank you, that's helpful. But a prior question is whether we have to, although, let's assume you're correct in saying it's too broad.
Yes.
Do we then have to understand what it is that is less than that would have secured the same objective? In other words, do we have to say, well, having 4 people there would have been enough?
No.
Do we have to go through that exercise?
No, Lord, in our submission, your lordships don't. It's sufficient for your lordships to say it's too broad. It's the council haven't failed to consider, and the judge failed to consider, whether a less restrictive prohibition in relation to what paragraph 1 is addressing was available, and they should now consider a less restrictive prohibition in the light of the reasons.
Can I press you on that?
Yes.
Because we have to be satisfied, don't we, that in this form there was a breach of the Article 9, 10 and 11 rights. We have to be satisfied there's a breach of those rights.
Well, yes, Lord.
I think.
Well,
that would be my position, because
yes.
Because that's your case, or your case is that that by imposing this order, there's been, I'm not sure, there's been a breach of your client's rights. Or you say we don't have to be satisfied. All we have to be satisfied of is that there hasn't been an infringement of the Article 8 rights.
Lord, our position is that if, as the judge accepted, this order significantly interferes with the Article 9, 10 and 11 rights of the appellants, then regardless of whether the order was justified or not, the order must be as restrictive, must be as non-restrictive as it possibly can be. I haven't put that very well, but
the claim in this case is that the order infringes your client's 9, 10, 11 rights.
Indeed.
And the court therefore has to form a view that he's done so. It's not good enough for us to say the council didn't go about it the right way. That's the Denby High School failure. So we have to form a view that it has infringed them. Now, in order to satisfy ourselves that it has infringed them, we have to be satisfied that it was a disproportionate way of meeting the Article 8 rights of the people in the locality, the visitors. So what I'm putting to you is, it's not, you're suggesting to us, it's enough for us to say it's too broad. What I'm saying to you, I think, is in order to form a view that there has been an infringement of your rights and an excessive protection of Article 8 rights, it's not good enough for us to say the council have to think again. We actually have to say it could have been done in a less intrusive way and explain why.
Yes.
And if that's correct, don't we have to say they could have said only a certain number of people needed to be there, only this needed to be done? Don't we have to do that ourselves?
Lord,
I don't want to do it.
No.
I mean, don't we have to?
My Lord, I think that there may be agreement between us, if I put it that way, because I readily accept that you will need to explain why it is your view that the prohibition could have been drafted in a less restrictive way.
Yes.
But what your lordships will not need to do is to actually redraft it. In other words, to reformulate the prohibition itself for future purposes.
do have to do, as I understand it, is when we get a combination of section 72
Yes,
and then 66(5),
yes,
the court may quash the order or variation or any of the prohibitions or requirements. So
Correct.
it's not simply, this is not wholly satisfactory when set against 72, therefore the whole lot goes, go away, local authority, and think again. The court, this court, any court, can sit and say, well, do the exercise that Liberty did,
yes.
say that bit has to go, that bit has to go, but that survives.
Yes. That's what it says
That must be
in
right.
66(5), the final sentence.
Yes, I think your ladyship is, I'm sure your ladyship is right.
No, please don't assume that, Mr. Havers. It's just that final sentence. After 66(5)(b), the court may quash the order or variation or any of the prohibitions or requirements imposed by the order.
Yes.
That, as I understand, is the point my lady's making.
Yes.
Yeah.
Well, I mean, what it states is the court may quash the order or any of the prohibitions or requirements. So, on the face of it, that gives the court power to look at this first prohibition and to say it's much too broad, and therefore we quash it. But you will have explained why you think it's too broad as part of your reasoning for quashing the prohibition.
Well, that's it. That is it. The decision of the court is to quash the entire order. As I read 66(5), it's in the alternative. The court may quash the order or variation or any of the prohibitions or requirements. So it's allowing the court not to quash the entire order.
Oh yes, no,
specific prohibitions and requirements within it.
Absolutely.
Right.
So this is very much our fallback position. If we fail to persuade your lordship and ladies that that the whole lot has to go, this is our fallback position. But reverting to my lord's question,
practicalities.
Yeah.
practicalities. I think the practicality is that if you're looking at quashing, if you decline to quash the whole order, so you're looking at my fallback position, and you're looking at whether you should quash any of the particular prohibitions or restrictions, then what you can't do is to rewrite any of them. If you think that, for example, this first prohibition is too broad, then
We can say it's too broad, and I'm thinking about burden of proof here now, because once we're satisfied that, for example, the rights are engaged, then the justification for any restriction on them lies upon the person who wishes to impose the restriction. So here we're assuming that the Article 9, 10 and 11 rights are both engaged, and we're assuming, for present purposes, that yes, the order is too broad. We don't have to say exactly how, but we are satisfied, for example, that by prohibiting a silent vigil with no further action, it plainly goes too far. Would it be easier then, in analytical terms, simply to say, well, the local authority haven't put forward any suggestion as to why there's some problem about doing something less the precise terms, and therefore we can quash it on that basis, that we're satisfied it's too wide.
Yes.
What precisely would be appropriate? There's no evidence on that, and we don't have to therefore address those points. I mean, for example, they could have said, I haven't gone through all the evidence, they could have said, well, it's simply, if you did this, it would simply be impossible to know what's happening, or whatever it might be. But we don't have that evidence, I understand it.
So
Well, no doubt if there is that evidence, then that will be pointed out to us.
subject to that, then our submission is that your lordships should quash the particular prohibition, and then it's a matter for the respondent to consider thereafter whether they wish to impose some less restrictive prohibition or not, in the light of the reasoning that the court would have given for quashing this particular prohibition.
Thank you.
So that's the first of the grounds, of the prohibitions. The second is at the top of page 228, interfering or attempting to interfere, whether verbally or physically, with a service user or member of the staff. What isn't? Well, again, we submit this is a prohibition which is too broadly drafted, because it is too vague. There's no attempt to define what is meant by interfering or attempting to interfere.
Now, it's a long time since I've done any what used to be known as non-mols.
I think I know what your ladyship's
I'm
referring to.
just non-molestation injunctions,
yes.
which are made under various legislative frameworks now. But are these the terms of art which are used within any number of different legislative backdrops?
Well,
I asked that, I don't know the answer to
No.
it, but it kind of has a familiar ring.
yes.
But it seems to me that if that is the case, then we would have to consider whether this is so vague that no one have any idea what it means, whether in fact that is looking at it completely in a silo, because in X number of different legislative backdrops, that's the term of art that's used all the time and everybody knows what it means.
Well, my lady,
I don't know if you can help me.
Well,
I'm simply going off
yeah.
the unhelpful ground.
well, I can't help your ladyship directly because we haven't carried out that exercise. No doubt, learned friend, if there is a good answer to it, we'll give it to your ladyship. My strong suspicion is that the expression means different things in different contexts and perhaps different statutes. But the key point we would make here is that those who are subject to these prohibitions need to know what is meant by interfering or attempting to interfere. I mean, does it mean, for example, does it cover, for example, simply handing or attempting to hand a leaflet to one of the women attending the centre? Does it mean seeking to engage them in conversation, as the first appellant describes in her witness statement? It's page 252 of the supplementary bundle. She's 252 in the supplementary bundle. I mean, she says that what she normally does is to offer a woman entering the centre a leaflet saying something like, "Hello, do you need my support?" Now, does interfere with cover that, or does it mean something more intrusive than that? And given that this order carries with it criminal sanctions for its breach, it is, we submit, self-evident that the order needs to be precise about what it is that it's prohibiting.
Mr. Davies, you say it's too broadly drafted,
Yes.
but really, the point, as I understand it, is the phrase interfering or attempting to interfere is vague and subject to misinterpretation.
Yes.
That's it, isn't
That's
it?
In paragraph 28, Liberty make the same point, but they say it's so vague that it's doubtful whether it could even properly be said to be formulated with sufficient precision to enable the citizen to regulate his conduct, which puts what I've just been saying into, as it were, conventional language. And they refer to the relevant authority at the foot of the page, footnote 8, which, to assist you, my ladies and my lord, is tab 8 in Liberty's bundle. And they too say it's unclear what is meant by interfering or attempting to interfere. As drafted, the prescription would potentially encompass a very broad scope of conduct, including, for example, an act of silently offering a staff member a leaflet in a manner which in no way obstructed or intimidated them. And then they make the same point in the context of the proportionality assessment. So we would submit
suppose also it would cover if you had a sort of stand or something with a whole lot of leaflets there, and somebody said, "Would you like to? Here's a leaflet if you'd like to take it."
correct. So we submit that in its present form, this prohibition should also be quashed for being too broad and too vague. The next prohibition is intimidating or harassing or attempting to intimidate or harass a service user or member of staff. Now, this is, or at least liberties say that this is a more targeted a prohibition than the first two, but we submit that it is still not formulated with sufficient precision. What is meant by intimidate and harass? I mean, harassment is defined in the Protection of Harassment Act in a particular way, but is that what is meant by harassment here? I mean, would it be said that seeking to engage, does this prohibition include seeking to engage a woman as she's entering the
It's a bit difficult, isn't it? Because I quite see the force of the point you're making and liberty you're making here, but you can't be expected to write a book explaining exactly every single type of thing which constitutes harassment.
I accept that entirely, my lord, but what was open to them was to provide some sort of link between the intimidation or the harassment to be prohibited and the activities that the council were concerned about. But there's been no attempt to link the two together. And as we'll see when we come to our sixth ground, the Murphy report sets out a list of the activities which Mr. Murphy says are derived from the evidence and about which obviously the council was primarily concerned. And there could so easily have been some link between intimidation and or harassment and the particular activities which the council had in mind should be covered by this prohibition. But there's no link at all.
Well, it's the connection presumably to the service that's being provided, right?
No, to connect some connection between what the word harassment or the word intimidation on the one hand and the particular activities that the appellants engage in on the other hand. I mean, it might be thought, or it might be said that even seeking to engage with the women by trying to talk to them amounts to or could amount to harassment given their very sensitive state of mind at that particular point in their lives. But the key thing is that the protesters don't know whether that's what is meant by harassment or not. A little over the page in the Liberty submissions, and so for that reason we submit that prohibition too should be quashed. Little d, or little 4, recording or photographing a service user or member of staff of the clinic while they are in the safe zone. Now here's a very good example of a completely clear and properly targeted prohibition, which about which no complaint could be made. Completely clear to the protesters what it is that they cannot do.
Does that mean that, making the assumptions you've made to get to this stage, that whatever happens to the other provisions in the order, this one could remain?
Correct.
Without you having to quash the whole thing?
Correct. However, the same can't be said of the the next prohibition, little 5 at the top of page 228, displaying any text or images relating directly or indirectly to the termination of pregnancy. Now that we submit in agreement with Liberty is an extremely broad ban, which again is wholly unparticularised. And leaves the, it's not only too broad in terms of its scope, but again because it's any text relating directly or indirectly to the termination of pregnancy, but it's also uncertain because of the reference to text or images relating indirectly to the termination of pregnancy. And I asked rhetorically, how on earth is the protester or the vigil attender to know what is meant by a text or an image which indirectly relates to the termination of pregnancy? Obviously, the concern was with the displaying of images of fetuses, and we see that. We'll see that again when I come to the last ground, ground 6. So the less restrictive and the much more certain alternative would have been to specify a prohibition on displaying any text or images which displayed images of fetuses. And that's a very good example of linking the prohibition to the activities complained of. So in its present form, we say that that too should be quashed. Lord and my ladies, the final prohibition was playing or using amplified music, voice or audio recordings. In fact, the appellants and the group with whom they're associated have never played or used amplified music or voice or audio recordings. That's been the other pro-choice group, the sister supporter group. So the appellants aren't, to be honest, particularly concerned about that prohibition. But it is to be noted that Liberty submit that also is a strikingly overbroad prohibition, as indeed we would agree it plainly is. And again, Liberty make the point in paragraph 36 that no attempt has been made to tailor the prescription to the interest which is sought to be protected. So it's any amplified music, any voice or any audio recordings, no matter what they may be about. So we respectfully submit that not only did the judge obviously not address those issues, but in our submission, if addressed, all but one of those prohibitions should be quashed. That concludes what I want to say about our fifth ground. Can I then turn to ground 6? And can I ask you to keep open the Liberty?
Can I just deal with the exceptions?
Yes.
The Liberty go on to deal with the relevance of the designated area.
Yes, they do.
And there are other prohibitions there.
Yes.
Do you want to say anything more?
Lord.
The way they have interpreted, Liberty's interpreted this is a second set of prohibitions.
Which indeed it is, yes.
But it's described as an exception from the earlier ones.
Yes.
So if the earlier ones go, what is the status of these?
Well, I hadn't considered that point.
Let's make it if the whole order go, obviously they go, but the whole order will presumably only get, it's the same point, the whole order would go only because of the paragraph 4 are all too wide.
Yes.
But since you've accepted that item 4 in paragraph 4 is not too wide, at least one possibility you've got to contemplate is that the whole order doesn't go, but everything in 4 apart from that little Roman 4 goes.
Well, I think that would be the consequence, but on a more broadly, it's difficult to see how the exception, that's to say the restrictions in the designated area, could continue to apply.
That's what I'm asking.
And I respectfully agree, because once
they're an exception. These are exceptions from the wider
correct.
prohibition. So if the wider prohibition goes, I think you would say, I would have to wait to see what, but you would say these go too.
Well, that must be. We would say that must be the consequence. Yes. Yes. And my lord, that's made even clearer if your lordship and the ladies would look at the map at 232. This which identifies the safe zone. And the designated area is within the safe zone. So, if the prohibitions that apply to the safe zone are quashed, all but one of them, then I think that makes the point even more forcefully. Thank you, my lord. So on to ground 6. And I know the court already have well in mind that section 72 of the Act, which provides that the local authority must have particular regard to Articles 10 and 11 when making a PSPO. Can I invite you to stay with the Liberty's submissions, because they helpfully set out in paragraph 18, beginning at the foot of page 11, the key components of Articles 10 and 11. Most, if not all of this, will be very familiar to the court, but can I just nonetheless remind you of it? So, top of page 12, Article 10 protects the right to freedom of expression, which includes the freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This protects not only inoffensive ideas, but equally those that shock, offend or disturb. Free speech includes not only the inoffensive, but the irritating, the contentious, the eccentric, the heretical, the unwelcome and the provocative, provided it does not tend to provoke violence. And then B is of importance. It protects not only the substance of the ideas and information expressed, but also the form in which they are conveyed. And read across to the present case, in other words, by the handing out of leaflets, or the offering of leaflets, and by the offer to engage in conversation. And of course, the signs, the placards that back that up. And before I take you to what it says about Article 12, can I at this point just invite you to turn up a case that the judge cited in his judgment, Annan, which is behind tab 16 of our bundle, Annan in Germany. if one starts paragraph 7, we can see that the applicant campaigned against abortion. He distributed leaflets in the immediate vicinity of the medical practices of two anaesthetists who ran a day clinic, and he deposited leaflets in all letterboxes in the vicinity of the clinic. The front page of the leaflets stated, in the day clinic, Dr. M, Dr. R, unlawful abortions are performed, and then that was followed by an explanation, which are, however, allowed by the German legislator and are not subject to criminal liability. The attestation of counselling protects the doctor and the mother from criminal responsibility, but not from their responsibility before God. The box below contained the following text: according to international criminal law, murder is the intentional bringing to death of an innocent human being. On the back of the folded leaflet, there was a quotation from a judgment of the Constitutional Court, as well as a statement by Goethe and Schiller's personal physician. And then the following text appeared on the back of the leaflet, top of the next page: the murder of human beings in Auschwitz was unlawful, but the morally degraded NS state allowed the murder of innocent people and did not make it subject to criminal liability. And below that sentence, the leaflet referred to the website www.babycourse.de, operated by the applicant, which contained an address list of so-called abortion doctors, and the list was accessible on the website under the link Death or Life Request for Prayers for Germany. So that was the factual background. Can I take you to page 397 of the bundle, and to paragraph 62, first of all. While the court furthermore accepts the domestic court's position, according to which the applicant's campaign had been directly aimed at the two doctors, it also notes that the applicant's choice of presenting his arguments in a personalised manner by disseminating leaflets indicating the doctor's names and professional address in the immediate vicinity of the day clinic enhanced the effectiveness of his campaign. The court also points out that the applicant's campaign contributed to a highly controversial debate of public interest. There can be no doubt as to the acute sensitivity of the moral and ethical issues raised by the question of abortion, or as to the importance of the public interest at stake. So again, one sees a repetition, if not slight extension, of what was said in Liberty's skeleton argument. And the appellants would say that being able to hand out leaflets to the women attending the centre and being able to seek to engage with them enhances the effectiveness of their campaign, and depends critically on them being able to do so at the entrance to the clinic, the centre, and being able to do so 100 yards away, 100 metres away down the road, as we'll see when I show you some photographs, is a poor substitute indeed for that right. And then in paragraph 64, the court picks up the point about the importance of the debate, having regard to the foregoing considerations, and in particular the fact that the applicant's statement, which was at least not in contradiction with the legal situation with regard to abortion in Germany, contributed to a highly controversial debate of public interest. The court, in view of the special degree of protection afforded to expressions of opinion which were made in the course of a debate on matters of public interest, and despite the margin of appreciation, comes to the conclusion that the domestic courts failed to strike a fair balance between the applicant's right to freedom of expression and the doctor's personality rights. Now, true it is that the Article 8 protection there was of the reputation of the doctors, but one can see, nonetheless, the way that the court, in this case, struck the balance, which was in favour of freedom of expression, notwithstanding what the activities of the applicant. Then, if I may, going back to Liberty's submissions at page 12, Article 11, although the protection does not extend to those who assemble with violent intentions, it does extend to assemblies of persons, even if their presence is annoying or offensive. I showed you Barankovic a little earlier in the context of Article 9. Without turning it up again, the relevant paragraph, it's referred to in the written submissions, it's paragraph 32 and it's tab 16 of Liberty's bundle. As noted above, bans which operate as a prior restraint on freedom of assembly are subject to a particular onerous obligation of justification, with which we would respectfully agree. The Article 11 right encompasses a right to choose the time, place and manner of the assembly and to ensure that it is within sight and sound of its target object and at a time when the message may have the strongest impact. All of that obviously highly relevant to the present case. And can I take you to the Lash-Mankin case which they rely on for those propositions? It's back to the Liberty bundle of authorities at tab 28. The background was, it's another case from Russia, and the background was the refusal by the authorities to allow various public events to take place, including protests, or at least alternatively the insistence by the local authorities that they take place at some different location. Can I invite your attention, please, to paragraph 405, which is at page 77 of the report. And it's probably simplest if I invite your lordships to read, and my ladies, to read to yourselves paragraph 405. And then, if you, and I would submit, I'm sure I don't need to develop the point that much of what is said there applies very critically to the present case. Obviously, the location is vitally important, and the means are vitally important as well. But can I then take you over the page to paragraph 412? And under general principles, can I just invite you to remind yourselves 142 of the citation from Krudvelilis, the right to freedom of assembly, one of the foundations of a democratic society, is subject to a number of exceptions which must be narrowly interpreted, and the necessity for any restrictions must be convincingly established. And then if you could go over to internal numbering from that authority 145, which confirms what you've already seen from Liberty's skeleton. Freedom of assembly protects a demonstration that may annoy or cause offence to persons opposed to the ideas or claims that it's seeking to promote. Any measures interfering with freedom of assembly and expression other than in cases of incitement to violence or rejection of democratic principles, however shocking and unacceptable certain views or words used may appear to the authorities to a disservice to democracy and often even endanger it. And in 146, the following paragraph, 4 lines down, where the sanctions imposed on the demonstrators are criminal in nature, they require particular justification. A peaceful demonstration should not, in principle, be rendered subject to the threat of a criminal sanction. So we submit.
I don't understand to be your case, because you're not clearly articulating as part of your case that if the Article 8 rights of those in the locality, the users of the service, are engaged, that nonetheless there should be no restriction of any kind, because the Article 10 and 11 rights of the claimants are so overpowering. I don't understand that to be your case.
No, that is our primary submission is that when the balancing exercise is carried out, it's impossible to say that the Article 8 rights of privacy of the service users justify that what the judge accepted was the significant interference in the Article 9, 10 and 11 rights of the...
I think I'm into a slightly more dramatic consequence, is that I didn't understand to be your case that there is no order that could be made which affected any restriction of any kind on your clients that would be justified, however narrow it was expressed, even take the photographic one. I don't understand it to your case under your, this is why it's slightly odd way of doing it,
Yes.
under your ground 6,
Yes.
which I think probably logically comes before ground
I
5.
agree.
But I don't understand it to be your case that nothing at all, even taking photographic images, could be justified for the reasons that you're taking us to in these cases, because your clients' rights to protest, to do what they're doing on a matter of controversy but public debate are so important. I didn't understand that.
Well, I think that is our case.
So you're saying that they should be allowed to photograph people coming in and out?
Well, my Lord, if I may say so, it's a very, very fair question. Because we have never, the appellants and the group with whom they're associated have never photographed, let alone sought to publish any photographs of the women coming in and out. I don't suppose they would be remotely concerned about a prohibition of that nature.
No, we have to consider the logical consequences of your submission.
Yes.
Is that really your case? You go so far as to say no matter how minimal, how intrusive that they may be, if your clients were, whatever steps your clients may seek to take in order to further their cause, that is legitimate, even though it amounts to an engagement of the rights.
No, I don't go that far.
I don't think.
No, I don't. Because
One real objection is that the order goes to, in weighing up the balance, the order goes too far. That's really your case.
Well, no, my case is that subject to perhaps photographs, anything else which interferes with the activities of the appellants and those with whom they're associated cannot properly be justified under the balancing exercise. Because if one simply looks at the activities in question, handing out leaflets, well, that it's impossible to justify that when balancing their Article 9, 10, 11 rights as against the Article 8 rights of the service users, we submit. The same with seeking to engage them in conversation. The same with carrying banners, displaying fetuses and the various stages of development of fetuses. In fact, perhaps this is the time to show the court the passage in the Murphy report that summarises the activities which plainly concerned the council. Can I ask you to take up the supplementary bundle? And if you could go to page 91.
This is the Murphy report.
This is the Murphy report. Now, at the foot of page 91, you will see a section headed "The Activities Identified by the Evidence Base." And if you go back to the top of the previous page, you will see what the evidence base consisted of. So, consultation and engagement exercises, obtaining information from the police, engagement with the clinic and clinic staff, taking witness accounts from those using the clinic, engagement with the local community, receiving and considering evidence packs produced by Sister Supporter and the Good Counsel Network. That's the organisation with which the appellants are connected. Further evidence has been received through the consultation process, and then first-hand evidence from council officers, interviews by council officers, 13 witness statements were obtained, that's paragraph 4.5, and then details of those witnesses as set out, some photographic evidence, 4.6, excerpts from the incident log, 4.7, maintained by the clinic, and 4.8, information obtained from a door knocking exercise. So that's the evidence base, and so Mr. Murphy at 4.1.1 pulls that together and summarises it in those bullet points that start at the bottom of 91 and continue down to the first punched hole on 92. And could I just ask you to read those bullet points to yourselves? So those are the specific activities which Mr. Murphy has derived from the significant evidence base. And apart from shouting, I suppose, which anyway is not what's carried out by the pro-life supporters, in our respectful submission, it's impossible to, or it's very difficult to say that any of those there can be a reasonable justification for prohibiting any of those activities on the basis of the Article 8 rights of the service users in the face of the Article 9, 10, 11 rights of the appellants.
So, Mr. Havers, as I understand it, all you're allowing for, let me use the word prohibition in a simple form, is the taking of photographs. Other than that, you're saying nothing else is justified.
I am. That's right. And indeed, if one looks, just looking at those bullet points, I think the word used in the court below was innocuous. Now, that may not be a particularly apt way of describing those activities, given the sensitivities of the women attending the centre. But with great respect, they don't amount to very much, we would submit. I mean, look, one of them is simply women feeling they're being watched and judged by a member or members of the pro-life groups. Well, these are members who are simply standing there.
But this is bullet points. You've got to then go to the court
I-
evidence and read the statements.
My lady, I accept that.
When you've read the statements, now they may be overreacting, they may be particularly sensitive, but to refer to what these women describe in their witness statements as innocuous.
Well, that's why I haven't used the word myself today. I said that the word was used below, and the judge has referred to it in his judgment. And I was referring to the activities as described in these bullet points. And I entirely take my lady's point about there being more in the witness statements. Not all of it, or a lot of it, not agreed.
Understood.
But this at least seems to be an accepted summary of the activities, certainly the activities that the council were presumably concerned with, because this is Mr. Murphy's summary of the evidence base in terms of identifying the activities in question.
And these activities are directly targeted at specific women.
Well, maybe they I mean, yes.
Yes.
I mean, I'm not going to beat about the bush on it. Yes. Yeah. I mean, your ladyship puts it pretty frankly to me, the use of targeted. But what and that's a slightly tendentious, if I may say so, way of describing.
Directed.
But certainly what the appellants and those who engage in the same activities are endeavouring to do is to engage with the women who seek to use the facilities provided by the centre. And so to that extent, they're obviously targeting them because that they are the women that they seek to engage with. That there wouldn't be any point in engaging with anyone else who was there because their message wouldn't resonate with them. But it's what they attempt to do, at any rate, as summarised in these bullet points, that we submit falls a long way short of activities that, I mean, these activities are undoubtedly being interfered with by the order. In fact, almost all of them are, according to the order in its current formulation, are completely prohibited. There's a blanket ban about all. That's a different point. But they are all. They are the activities which the appellants engage in or seek to engage in. That the order undoubtedly represents a significant interference with their Article 9, 10 and 11 rights, their rights to do this, to engage in these activities. And so the question arises whether the carrying out the balancing exercise, the protection of the Article 8 rights of the women using the centre justifies a significant interference with the Article 9, 10 and 11 rights of the appellants manifested by the carrying out of these activities. And what we say is that when you actually look at the activities in question, particularly as summarised here, I take my Lady King's point about there being more to be found elsewhere in the evidence, but it's not agreed that these activities don't begin to justify, through the prism of the Article 8 rights of the women using the centre, the interference with the right to manifest their religion, the right to free speech and the right of public assembly, and what those rights amount to, as I sought to demonstrate through the authorities, the right to choose where you protest, to try to convince others that you're right and they're wrong, the right to engage in protest in the way you choose to engage in it and at a location of your choice. And so when one looks at the importance of and the characteristics of the Article 9, 10 and 11 rights, the balancing exercise we submit must come down in favour of those Article 9, 10 and 11 rights rather than the Article 8 rights of the service users. And that, in a sense, is our submission on the on this sixth ground. I mean, and even if you are persuaded to look beyond these activities, the bullet point summary of the activities, and look at the rest of some of the rest of the evidence, we submit that even then the balance should come down in favour of the rights of the appellants under Articles 9, 10 and 11. I'm not going to improve that final submission by repetition. So far as the respondent's cross-appeal is concerned, I was proposing not to address that now, but to address it in reply once my own friend has addressed it in his submission. So unless we can assist my ladies and my lord any further.
Thank you very much.
Thank you.
It's very grateful to you. Yes, my lord. Ladies.
Well, what I propose to do is to divide my submissions into 6 areas. Firstly, I propose to make some background comments about the nature of this appeal, about the nature of the particular clinic we are concerned with, its geography, and then to give some detailed consideration to the evidence that was before the respondent, because that evidence frames the considerations of the issues that arise here, particularly under the Convention, in relation to engagement of the service users' Article 8 rights, and then in the balancing exercise that's been undertaken. And I was proposing to shorten that, but in the light of the approach taken by my learned friend, saying, in effect, it doesn't amount to much, I'm afraid I'm going to have to take it in quite some detail, if I may. My lord, the second submission.
Well, there's detail and detail.
Obviously subject to the court asking me to move on. But the second point is that the judge was right to interpret the phrase "in the locality" as capable of applying to a person who was there on 1 or 2 occasions only. The third is that the judge was manifestly right to hold that the service users' Article 8 rights were engaged, and at the same time I'll deal very shortly with our cross-appeal as to the rights of those accompanying the service users and employees. Then the fourth area is that, assuming the judge was right on his interpretation of the statute and on Article 8, that his approach to the question of proportionality was not wrong, and therefore this court has no entitlement to itself to consider the matter. Then fifthly, if the judge was wrong, then clearly it falls to this court to determine the proportionality of the interferences with the appellant's Article 9 to 11 rights. And then sixthly and finally, I will deal with the ground 5, that is, the judge failed to give sufficient consideration to whether the order could have been formulated less restrictively, and also picking up at that point some of the intervener's submissions, which the appellant has not made, but has now hitched its bandwagon to. Lord, in terms of the background, this case is not about the general use of the PSPO legislation or the intervener's concerns about its uses in other contexts. But one notes it has concerns about use in relation to the homeless. It is simply about whether, on the particular evidence before it, in relation to this particular clinic, in its particular location, the respondent was entitled to make this order. And that order was designed to protect service users, those visiting and accompanying them, those working at the clinic, and those living and frequenting the locality from the ongoing activities of both pro-life and pro-choice activists, which activities had been going on unchecked for many years, where the authority had sought by liaising with the represented groups to reach an accommodation and had failed, and where, until the making of this order, those wishing to exercise their right to have an abortion at this clinic had no alternative but, in effect, to run the gauntlet of those who are outside. My Lord, we consider it is important for the court to have a clear sense, as I know it will, of what is involved in a woman's decision to have an abortion and thereafter to make an appointment at this clinic. Because what is critical here is that the time at and the place where the activities take place is on the very day, at the very place, in the minutes immediately preceding and the minutes immediately after a woman has in fact had an abortion at a point in time when she has already reached her decision. And that day is described by one of the service users as the worst day of her life. And it follows necessarily that these impugned activities take place at a point in time when a woman is attending for an intensely private medical procedure at a time of acute, intrinsically private emotions and feelings, both physical and psychological, and those feelings can include vulnerability, anxiety, perhaps uncertainty or guilt, as well as everything physical. And my Lord, of course, I think the evidence before the local authority was that 1 in 3 women will, by the age of 45, have an abortion. And it is a matter of fact that a number of those who attend this clinic will be children having abortion. Because the evidence before the council was that some 16% of service users of clinics are 19 or less. So a considerable proportion will in fact be children. And the court, from reading the witness evidence, will recall one statement from a service user who attended the clinic more than 10 years ago, in 2007, in the middle of her GCSEs, in school uniform. And 12 years later, in fact, felt so moved and upset by what had happened to her to make a witness statement to the council. So these are the real background matters to which this court is concerned. And my Lord, as the court well knows, the reason for a woman having an abortion are many and varied. The evidence here shows that the principal reason is risk to the physical or mental health of the woman if she continues with the pregnancy, so unable physically or emotionally to continue. And other reasons can, of course, include fetal abnormalities, including fatal fetal abnormality, and may also be victims of rape or incest. So any woman who decides to have an abortion, finding herself in this position, will have made an incredibly difficult decision and will have made her own moral choice. And my Lord, some of these points were recognised by the Supreme Court in the Northern Ireland Human Rights Commission case. May I take you to that, please? It's tab 23 of the authorities bundle. I do refer to some of these passages in our skeleton argument. Lord, can I take report first, please, to paragraph 6 on the judgment of President Baroness Hell, and it's on page 647, where she says as follows: the starting point for any discussion of the legal issues has to be the right of all human beings, male and female, to decide what shall be done with their own bodies. The right has long been recognised in the common law. It is the reason why consent is needed for invasive treatment. Miss a couple of lines. It's also recognised by the Convention, see pretty, where it's said that the notion of personal autonomy is an important principle underlying the interpretation of its guarantees. For many women, becoming pregnant is an expression of their autonomy, the fulfilment of a deep felt desire. But for those women who become pregnant, who are obliged to carry pregnancy to term against their will, there can be few greater invasions for their autonomy and bodily integrity. And then paragraph 8. By definition, we are here considering the cases of women and girls who either didn't want to become pregnant at all, or having experienced the joys of a wanted pregnancy, have reached the agonising conclusion that because of the fetal abnormalities, they do not wish to carry the pregnancy to term. Miss a sentence. Any woman or girl who finds herself in such a situation and wants an abortion will have made her own moral choice, often a very difficult moral choice. The question of whether others, many of whom will never be placed in such a situation, are entitled to make a different moral choice for her and impose upon her a legal obligation to carry on pregnancy to term. Well, then, can I take you to a short passage, paragraph 280 of Lord Kerr, which is on page 729. And it's the first sentence starting on the top of page 729. A woman's right to respect for her private life, her right to exercise autonomy over her own body, her entitlement to make decisions as to her own welfare and happiness, lies at the very centre of her existence. Interference with the right to be proportionate must be no more than is necessary to achieve the aim that it is designed to fulfil. And finally, my Lord, may I take you slightly back in the judgment, paragraph 84, on page 676, where Lord Mance, at paragraph 84, refers to the risks of women who have a fetal abnormality, and he's referring to evidence of Professor Dornan at D. He says, Professor Dornan also explains the risks of, in particular, sepsis, the physical health of a mother of an abnormal fetus, which may die and remain undetected in utero for a significant period, up to 2 weeks, as well as the significant risks to the mental health of a mother required to continue with a pregnancy, knowing that her baby has a fatal abnormality and may die at any moment. And he then goes on to consider the examples of the number of women who had supported the Commission's case here, describing in quite harrowing detail the circumstances they had undergone. And he uses that word harrowing for himself. And that includes a number of women who had to come from Ireland to England for their abortions. My Lord, the points made by, that's what I need from that authority. My Lord, the points made by Lord Mance in that case find resonance in the evidence before the respondent authority here, because there was evidence of service users having to cancel their appointments because of the actions of protesters. For example, on the 23rd of February 2017, a local resident saw a service user prevented from entering for 15 minutes, and she walked away appearing in severe distress. And there's also evidence from the Mary Stopes clinic itself about the effect of cancellation, because of course that means women have to have later treatment at higher gestation, and that reduces treatment choices. And it's also right that there are evidence of clients who have come all the way from Ireland to this clinic. One who was too frightened to walk past the protesters and staff had to go and walk her in. So that's the reality here. And then similarly, the points made by Baroness Hale about the difficult choice that a woman makes is also reflected in the evidence before the council. So one service user said the decision to terminate was harder than she could ever have imagined. There was a month's delay between her finding out she was pregnant and then the appointment itself. And she dreaded the day, but she'd gone through her options. Another one was nervous and reluctant. It went against all her parents had taught her. It was a moral dilemma, and she was young, but it was right for her at the time. And yet another was the hardest thing that she had ever done. So these are decisions that women have taken, having gone through their options in these circumstances. And the question ultimately that this appeal is concerned with is whether, having made that intensely personal decision, a woman is entitled then to go through with that choice, privately and confidentially, as you'd expect of any other medical procedure, and without having to engage with or be sought to be engaged by people you have never met, who do not know your circumstances, and whose very reason for being there is to seek to get you to change your mind. And we say, manifestly on the evidence, that is not right. And in due course, I'll submit that the women's Article 8 rights are clearly engaged, the interferences with them are highly substantial, and as and when one comes to balance their rights with the 9, 10 and 11 rights, there is, with respect, no other conclusion to which the court can properly come, but that their rights should take precedence. Well, just two final points by way of background. The fact that many of the impugned activities are not undertaken aggressively, or indeed are engaged in by those which the activists perceive to be for the most noble reasons, it doesn't provide an answer. It doesn't mean that the effect of their activities is not traumatic or upsetting, or that the service users will not feel intimidated or harassed or shamed or made to feel guilty. Indeed, the evidence demonstrates to the contrary. And the second point is not an answer either to say that some service users may in fact be happy to engage with those outside, or indeed that some may ultimately change their minds. Because as the judge said, that was why it was important for the authority to gather evidence, saying if that was the position, to see what the preponderant impact of the activities on the service users was. It did so. The evidence was clear that the impact was negative and intrusive and significant, and so it acted. Well, can I now say a little bit about the geography of the clinic, which is quite important actually in this case. Can I ask you please to go to the supplemental bundle, tab 20, page 317, where we have some photographs. So the clinic here is in a predominantly residential street, and it's next to a park. And access to it is and can only be on foot by way of the highway. There is no parking provision on site for clients. So on page 317, we see the two brick pillars and then a long internal entranceway that service users have to go from the highway to get to the clinic. Then on 318, we see the very substantial verge, which is outside the clinic, upon which a number of the protesters congregate. 319 shows the vehicular entrance for members of staff. It's quite possible for service users to go in that way, but equally there is no way they can do so without coming across those on the highway. And then page 321, this is the designated area within the terms of the order. It's some 23 metres wide, between I think 1.89 metres and 5 metres, 8 metres wide. And one sees it again on 322, sees its length. And then at 323, this is standing from the designated area, looking down towards the clinic. And the clinic can be seen in the distance. My lord may be able to see someone wearing a yellow-coloured cardigan, just about an inch to the right of the lamppost. So those are the...
Sorry. So the person taking the photograph is where in relation to the designated area?
My lord, that is starting at the edge of the designated area by the highway on Culmington Road, and looking down towards the clinic, yes, which the evidence is about 100 metres away. And one can see from page 323 that this is a very open residential street with very considerable grass verges. And therefore, anyone coming to the clinic is visible from the highway for quite some distance, and to anyone who chooses to station themselves anywhere on the highway to keep a lookout. And indeed, the geography of the area and the routes into it from public transport determined the size of the area. There's evidence before the Cabinet, we'll look at it later, that the setting of the limits of the safe zone was to ensure safe pedestrian access from all major routes. So from Ealing Broadway, the tube and train station, and from the main bus and pedestrian routes from West and South Ealing. And as that report shows, officers did not consider it could be any smaller in order adequately to protect the service users. So that's if one comes by foot. One could equally come by car. If one comes by car, one has to find somewhere to park. Again, one is immediately visible. And as one service user said, as soon as they park beyond the clinic, closer to Cullington Drive we see here, she could see the protesters had their eyes on us and were waiting. And another, even when coming by minicab, as soon as she saw them, she immediately started to panic. So that's what we're dealing with, a very open geographic limitation where women coming to this clinic are there to be seen. In addition, as the photographs show, the front entrance door is set back quite some way. One has to access between those two substantial brick pillars. It's very easy for someone to stand in the way, requiring a service user to go round them if they don't want to engage. There isn't free access. And when service users leave, unless they've pre-booked taxis, they have a considerable distance to walk away from the clinic, having had an abortion, possibly bleeding, and suffering all of the physical and psychological difficulties there are. And the evidence before the Cabinet from Miss O'Brien, BPAS's, Mary Stopes' area manager, was that she has personally seen women being followed up the street by pro-life protesters after leaving the clinic. And the other point, of course, is that being predominantly residential, one doesn't have the footfall that one might have on a commercial street where you have many, many people passing through. And so any woman of reproductive age, and the evidence before the committee was some 99.9% of service users are aged 45 and under, is again immediately identified as a person likely to go there. So that's its geography. As to the nature of the clinic itself, it is not a general practice. Far less is it a hospital in which there are many departments, and so when one goes in the front entrance, one could be going in for any number of purposes. It specialises in providing medical and surgical abortions, also provides us some family planning and vasectomy services. So again, that also identifies those going as the reason for their visiting. And that's a fact known to activists. It was said, I think somewhat faintly, by my learned friend, that women could choose to go somewhere else. Well, I suppose they could, but why should they? And the evidence again before Cabinet was, or rather the evidence before the court, is that I think some 98% of Mary Stopes' clients are NHS funded, and the NHS doesn't have the capacity to carry out abortions. So it is performing functions on behalf of the NHS, and women are entitled to go there. And many do. Because in terms of the numbers attending the clinic, the evidence before the Cabinet was that there were more than 15,000 visits a year. Take that from the Mary Stopes' submission, which equates to about 50 per day on the basis that is open 6 days a week. And so when one combines overall the particular location of this clinic on Mattock Lane with its geography, with its specialism in abortions, and the fact that it is women of 45 and below who will be seeking them, the scope for service users being immediately identified and singled out for activists is abundantly clear. So those are background points of evidence. Turning then to the impugned activities and their effect, we submit that there was a substantial body of evidence before the Council which cogently demonstrated that the effect of those activities on service users and others manifestly entitled a PSPO to be made, and its terms of which were not incompatible with the appellant's convention rights. And there is a large body of evidence in the bundle. What I was proposing to do was to take the court to 4 of the witness statements of the 13 for women, 2 of the witness statements for the local authority employees, some of the photographs and video stills, that was before the Cabinet, and short elements of the responses from Mary Stopes, BPAS and the statutory consultation. And I would seek to do that because this is not a case where it's all a storm in a teacup. The actual activities and the effects of women are critical to the balance the court will ultimately have to make. So we're dealing first with the witness statements. There were 13 before the Cabinet, including a number from previous service users who'd used the clinic between 2005 and 2017. So there was a remarkable consistency in what they said over that long period of years. And it's also noteworthy from reading them that even those who experienced the effects at this clinic many years ago have still suffered long-standing effect. The appellant, in their skeleton argument, seeks to characterise the impact on service users as little more than shock, offence or disturbance. That's how they put it. That is, we say, a deliberate and unwarranted downplaying of the body of evidence that should be rejected by the court. May I take the court first to supplementary bundle page 200, which is client A, 2005. And my lord, I appreciate that my lord, my ladies will have read the statements, but I do feel it important that we should just highlight some of the points here. So, client A was a client in 2005, and in paragraph 1 notes she still recalls experience which had a significant effect on her. She was 17 when she came. Paragraph 2 went against my Catholic morals, but after deliberation I felt the termination was best for me. She spoke, paragraph 3, to another married woman, and then she reasoned up for herself. Last paragraph, it made me relieved the decision I had taken was the right one for me. I knew that I might feel some guilt later on, but I was feeling positive and accepting my decision. Then paragraph 4, she talks about what she witnessed on leaving the clinic, directly confronted by 3 to 5 protesters standing outside. She was absolutely horrified, will never forget that experience. It turned from a peaceful and leafy environment to a group of protesters with horrific images. They were holding rosaries and they were praying. In paragraph 5, they didn't say anything to me, but the images were enough. I remember quite clearly that one of the images was of an 8-week-old dead fetus, the same as the age the one I was carrying, which she found horrifying and traumatising. She says, top of page 201, her first instinct was to run, and she asked them something, and they told me they were praying for the souls of dead babies, and that, unsurprisingly, I'd submit, made this young woman feel overwhelming guilt. And she then says the effect seeing those images had upon her, and there was an episode of mental health problems. And then she goes on in paragraphs 9 onwards. Paragraph 10, I felt they were judging me as a terrible person, praying for the souls of the dead fetus, but not the mother. And then paragraph 11, the whole thing is imprinted on my mind. Well, that's the first statement. Can I now go to page 210? And that is client E, who attended the clinic in 2010 and in fact still lives and works in the locality of this clinic as well. And client E was 18 when she attended, and what happened then still makes her angry to this day. Paragraph 3, she was nervous and reluctant. It went against everything she'd been taught by her parents. I've already mentioned that in opening. And before going, her appointment was on the 27th of August 2010, but she went a few days in advance, understandably so, because she was nervous. And when she was there, she saw protesters there. Third last sentence, paragraph 4. Their tone was kind, but their words were foreboding, and it gave me this impending sense of doom. Then paragraph 5. They were not physically blocking her way, but they were making it difficult for her to walk up the drive and through the door of the clinic. They were edging around her rather than obstructing her. And she gives the example of having to dodge charity workers. And she felt dismayed by the situation. And I was going to have them judge me for what I was about to do. So, paragraph 7, she says she was only there for a couple of minutes, but seeing them was traumatic. She refers to one of them having had a sign with some sort of biblical passage, and she remembers thinking, oh my God, I'm going to hell. What am I doing? Why am I doing it? When I saw it, it put me in turmoil. She was heaving and wanted to vomit. She decides to flee before one that spotted her and started on her. She says having a termination is traumatic, but this reaction was down to them being there. The clinic was not the house of horrors that I had envisaged. It was their presence that made me react and made the whole thing seem 100 times worse. And then she goes on in paragraph 8 about her own attendance on the 27th of August, having steeled herself, knowing what she was going to see. And she says on the third line down, as soon as I got to the junction of Culmington Road, which crosses through Mattock Road, and I saw the group there, my legs began to shake and I stopped in my tracks. I can't say it's purely down to them, but seeing them made my legs turn to jelly. And then she goes on to say what they were doing. There were 3 of them. There was a white female sitting on a chair on the grass verge. She was praying. And then from further on, a male with rosary beads made a beeline towards her. She says his tone was nice, much nicer than the one the day before. But she remembers feeling very claustrophobic because they were getting so close. She was stressed and nervous, and they were surrounding her. She needed space, but as soon as she walked through the door of the clinic, they started praying. That made her feel even worse, as she says, Catholic guilt. I did not need to feel any guiltier than I did. Before they started praying, I did not think that it was possible to feel any worse. She goes on in paragraph 10, having left the clinic and having had her abortion, and being under the influence of the anaesthetic that she had had. This had become the worst day of my life. I was in tears and wanted to rush away. I walked up the gravel drive and across the green verge directly opposite the clinic. One of them walked right up to stop me from roughly 15 to 20 metres away. He gave me a light blue leaflet and said counselling on the front. When I opened it, I saw an image of a dead fetus. I was about to faint. She asked why he would give me this, and the only word she recalls from his response was condemnation. And she also says in paragraph 12 that she went downhill after that. The protesters don't seem to realise that women do not get pregnant to have terminations. Their presence is disturbing, and when they started talking to you, it feels worse. And she goes on to say that she lives and works in the area. She has never been able to get over her experience when she sees others, them harassing others. In paragraph 13, she accepts, of course, the termination was horrible, but their behaviour was worse. God forbid that I was in the same situation again and went to a different clinic. I still think of them. And she makes a comment in paragraph 14. They have upped their signage since then. Before, there were Bible passages, and now there are pictures. That is client E. Can I then go, please, to client D at page 207? And client D visited on 2 occasions in one occasion, I think, in 2000, this was two occasions in June 2017. And in paragraph 3, she refers to the first day. She went with her mum. Their route was through the park, and they saw 2 or 3 people standing there with rosary beads and signs, standing on the green 2 metres from the clinic. And she knew of them because she lived in the area. And what she says is, knowing they were there made me feel even more anxious to see them. I knew they were going to judge me, but I was happy with my decision. Their sign said, "You could be a mother," and they were watching me. I just burst into tears. I tried not to look at the signs because I knew they would not be nice. She then speaks about a ginger-haired man coming over to speak to her. She said he had a grimacing look. He had rosary beads, and he said to her, "I'm going to pray for you. You don't have to do this." He made me feel like I was wrong. I made a concerted effort not to look at them. She says the most distressing thing was the pictures. I felt like they were turning my action of having a termination into the murder of a baby, which is not what I was doing. They made me feel guilty as if I was a killer. The next day she returns, this is paragraph 5, this time she goes with her boyfriend, who commented to her, "Geez, this is tough," they get in. She felt safe once inside the clinic. Paragraph 6, my experience on leaving was a bit of a blur. There were pictures on the grounds of fetuses going through the stages of development. I could not help but look at the protesters' signs, and I ran into Walpole Park crying. Hardest thing I'd ever done, and they made it 1,000,000 times worse. I felt so vulnerable. She talks in paragraph 8 about the awful dreams that she has had, and that they are nightly and still going on. And she has seen that man, Oliver, in her dreams multiple times. He appears with his rosary beads in his hands when I have looked, when I've been looking for my lost baby. And then paragraph 11, 4 lines down. People undergoing a termination have gone through a huge thought process. I had to have discussions and get signed off by the doctor. I had gone through the options available to me, and I did not need someone standing outside on the day of the termination. In paragraph 16, I have not been able to walk past the clinic since. I would break down if I saw them. We drive a different way, as I cannot bear to see them because of them. And finally, my Lord, of the 4 statements, could I go now to page 184, which is a client in 2017. And think from paragraph 1 that she went in early 2017, a statement being made in December 17. And paragraph 3, she refers to how she became pregnant accidentally, but the decision to terminate was also harder than I'd ever imagined. And she speaks about the month's delay that I've already referred to. Paragraph 4, she drove past the clinic. She could see protesters outside, loitering around near the front door of the green. And in paragraph 5, once we had parked, we walked up towards the clinic. I could see the protesters had their eyes on us and were waiting. They went up the driveway, and then the young male protester came over and said, excuse me, can you come over?" Her partner didn't realise it was a pro-life protester, and he acknowledged him. The protester then said, "I want to speak to your girlfriend." And he was holding an A4-sized picture of a fetus on an embryo which had 10 to 11 weeks written on it. He was showing the picture, and she froze. I wish I hadn't frozen, but he made me feel intimidated. He again said, "I want to talk to your girlfriend." And what she says, and this is material to the points being made by the appellant, that I know that on paper this behaviour doesn't look intimidating or aggressive, but I would take walking past a mob of youths in a dark alleyway rather than have experienced that, because context is absolutely everything. In paragraph 8, refers to her partner going out to get some fresh air during the afternoon. The protester was outside, said, "It's not too late, go back and get her." And lined up were, in chronological order, the pictures of fetuses. She says again in paragraph 10, "On paper, the protester's actions do not look bad, but I struggle to deal with it. I cannot imagine being alone, young, and vulnerable, and having to face them." And she also says, paragraph 11, that she has since had dreadful nightmares and flashbacks. She knows that the termination plays a part, but the protesters have had the biggest impact on her. She has recurring nightmares, about 4 or 5 times a week, specifically about them. She dreams about them chasing her, hurting her, judging her, trying to get her outside the same clinic, not letting her get on with her business. She says the last sentence, those few seconds with the protesters still invoke strong feelings of sadness and anger. It makes me feel teary, horrible and vulnerable. Well, those are the 4 witness statements. Now, I appreciate that my learned friend says that this evidence is not agreed, or it doesn't need to be agreed. This is evidence that was before the respondent decision maker, and it's clear from its decision that it accepted this and a great deal of other evidence as demonstrating the effects on the service users of the impugned activities. Before going to some more statements, may I take you to some photographs, please, at page 169 of the supplemental bundle. And these photographs were provided during the statutory consultation as part of Sister Supporters' submission. And the first one on 169 was taken on the 14th of July 2017. That was a Friday, and so this was the Friday morning protest that one sees reference to in the papers. And one can see 5 individuals lined up just to the right of the clinic entrance, and then on the text it says, middle paragraph, on the floor under the number 87 you can see medically inaccurate images of fetuses, and their signs read from left to right, thou shalt not kill, abortion, 1 dead, 1 wounded, give your baby a present, a birthday, and abortion kills babies. Page 169 contains 2 photographs. Sorry. Page 170 has 2 photographs. The top one is one of the larger vigils, and the note in the second paragraph states, we've also been told by the clinic that the prayers can be heard from the consulting rooms, which understandably distresses patients. And one has to, of course, well, you have some 20 or 30 people here standing outside on a Saturday when a woman, perhaps a child, a young woman in any event, is going into that clinic to exercise her right to have an abortion. You can only think about the effect upon her. The bottom photograph on page 170 is the woman wearing the blue jacket that one sees in page 169, and one can see the sign that she is holed up. It's described by Sister Supporter as a gruesome image. Medical professionals have confirmed is not that of an aborted fetus.
Sorry, where are we reading from there?
That is the first paragraph of text on 170 opposite the photograph of the woman in blue, my lord. Then page 171, this is the standard Good Companion Network counselling. Unclear if Good Counsel Network counselling. Unclear if the woman there is one of the paid employees, but nonetheless one of their activists. And the text says, the woman in the navy coat is seen calling down the path to the clinic, standing on clinic property, and continuing to harass a person that's asked to be left alone. And the bottom photograph is a model of a plastic fetus that was given to a resident by a man standing at the clinic gates who mistakenly believed she was a patient at the clinic. And models like these are given out to women using the clinic with the intention of upsetting them. And then page 172, there are 2 stills from videos taken by Sister Supporter of another of the GCN activists. This is Monday the 17th of July 2017. One sees the gentleman there in the white shirt and the cap. And the transcript reads, this is 11 weeks and that's 10 weeks. The first pill stops the baby's nutrition, and the second pill, ... But the baby's life can still be saved if the mother's only taken 1 pill, and in some cases we actually found the mother's baby's life can be saved even when she's taken 2 pills. He goes on to ask her about if she's having a scan. He says, they won't show you the scan, we can show you the scan, and offers her a rosary. And one can see in that photograph he's holding blue and pink rosary beads. I'll be submitting in due course it's no surprise that the rosary beads used by the activists are blue and pink, just as it's no surprise that the leaflets that they have prepared and give out to women are blue and pink. The photograph on the bottom shows that same man speaking to someone who is off camera, but clearly not on the clinic properties. And the transcript says, "Mum, please take one. I'm truly sorry, but God will forgive you, but we encourage you to pray, because if you pray, you won't end up back here, Mum." We assume that is a woman leaving, having had an abortion. He is calling her a mum. She is not a mum. She is a woman who has had an abortion. The effect of telling her to pray can only have had an impact upon her. And then the sentence, "If you pray, you won't end up back here, Mum." Well, let me say about that. And then that same gentleman, page 173, Friday the 4th of August 2017. Again, he's holding pink and blue rosaries. And the transcript is, "We encourage you to pray, and God is a God of mercy, and I'm truly sorry. Maybe change your lifestyle, and you should have kept your baby today. God bless you." So that is direct photographic evidence and transcript evidence which hasn't been called into question by anyone. Returning to the witness statements, can I now take you to two of the statements from my client's employees, because it may be said, well, you have to discount a great deal the evidence from Barry Stopes' employees because they have an interest. So if one looks at my client's witness statements, the first one is at page 175, and that is Miss Shaw of the Safer Communities Department. And she attended on 4 occasions in November and December of 2017. And she gives some narrative description, which I don't take you to. At paragraph 11, she refers to her return to the clinic at 13:35 on the 21st of November. And she says in paragraph 11, "The first female with red stroke auburn coloured hair that I observed in the morning was now walking between the 2 pillars directly outside the entrance of the clinic. She had multiple blue and pink coloured rosary beads wrapped in one of her hands and a pile of leaflets on the other. As I walked up to gain entrance, she spotted me and stood in front of me, blocking my entrance into the clinic. I asked the female to excuse me, and she turned to let me through. She thrust a leaflet in direction and said, 'Don't do it. We can offer you assistance.'" And Miss Shaw ignored the comment and made her way inside the centre. Then page 177, paragraph 16. She is recording a conversation she had with a service user that she met within the clinic, and the service user tells her, paragraph 16, that she explains to me that she was approached by a female standing directly outside the clinic as she made her way inside, who said to her that abortion was wrong. "We can help her. We can help you." And the only other point to draw from this statement is if one goes to paragraph 20, please, on page 178, Ms. Shaw speaks about the atmosphere at the clinic later that same day. So it's a Saturday, and so there is a counter demonstration. And in paragraph 20, she says, "At 9:55, I popped outside. I viewed 8 pro-life protesters and 7 pro-choice protesters on behalf of Sister Supporter who were wearing highly visible, wearing a bright pink coloured high-vis jacket, and the pro-life groups singing hymns fairly loudly." She says in paragraph 22, "The atmosphere outside the clinic was tense and felt unfriendly and confrontational. It made me, as a member of the public as well as a professional, feel uncomfortable." And then her next experience, 1st of December, she witnesses a heavy presence of pro-life and pro-choice protesters. And similarly so the next day, 2nd of December, paragraph 27, she walked out and saw an increased number of pro-life protesters, about 19 to 20, singing hymns loudly, and 9 pro-choice protesters, again standing there. So that's her statement. And the point is that My client doesn't want anyone there. He doesn't want any protesters there. Now, the pro-life protesters and the pro-choice protesters are each exercising their Article 10 and 11 rights. And, subject to anything else, they're entitled to, and that is what one has in a fiery, proper democracy. But where they're exercising their rights against one another further exacerbates the position for service users exercising their own rights who want no part of it. That necessarily will be something to be taken into account in the balance. The other statement is that of Nora Yamut at page 193. She is employed as team leader by my client within the Safer Communities team, and she also attended on 3 occasions in late November and early December 2017. And paragraph 7, she refers to the 21st of November 2017 when she was in the clinic and coming out. And she says, I left the clinic at approximately 11:30. I walked up the driveway and out the main gate, stopped by a white female. She stated to me, if you pray, my dear, you will not come here again. The baby that died is probably with God. And she speaks about having been stunned. She says she didn't do anything. And the woman gave her 2 leaflets and a rosary bead. She also then goes on to speak about the 24th of November, in paragraph 8 onwards, where there was a counter demonstration. And then paragraph 12 records speaking to another female service user who was on her own at 3:25, and she told her she'd been approached when she attended the clinic the day before at about 3 o'clock, and she recounts that upon leaving she turned left out the gate and saw 3 or 4 A4 sized full colour pictures of different stages of development that caught her attention, and the person there said, how old is your baby? And started showing her the pictures and explaining the stages. She also asked her, do you know what's going to happen upstairs? Gave her a leaflet, and that client expressed the view that she felt very embarrassed and horrible because I had made up my mind about the abortion. And she says a bit further down, the client said to me she felt the protester was trying to dissuade her from having an abortion, which made me feel ashamed and remorseful. And she was really upset when she got home and wanted to cry because of that interruption. She says, although she knew the protesters are trying to do good, they do not know my situation. Then, moving further on, paragraph 14 onwards, 8th of December 2017, she reattends and sets out what she sees in paragraphs 15 and 16, including top of page 16, the last picture that was outside in the gateway entrance was of a small blonde baby. And then she recounts 2 further conversations with service users in paragraph 18 and 19, including the one at paragraph 19, where she met a young client who was very quiet, and her aunt told her that on arrival her niece was shocked and taken aback when she saw the protesters, and she's gasped out loud. And she recalls also the aunt having been there 2 years before, having brought her sister, and she remembered the protesters saying, keep the baby, which was horrendous to the sister, who did want to keep her baby. And as she said to Miss Yamut, last sentence, she said to me, just as you can't force a termination on someone, you can't force pregnancy, which is what the protesters tried to do. And then finally, she recounts in paragraph 20 her own involvement with one of the protesters when she leaves at 3:50. She returns to the clinic at 3:50, and a male was there. He said, hi, this is for you. He kept calling me in a hushed tone, but persistently, even as I reached the door and I turned around to face him, I could then see he wanted to give me a leaflet. And he said, we have a women's centre on Edgware Road. We help women not to go through their abortions. She took the leaflet. So those are the 2 witness statements from the local authority. Can I now go to the witness statement of one of the Mary Stopes employees, which is a bundle, same bundle, page 187. And this is Stephanie Goncalves, who is employed as a supervisor and has been so since August 2016. And she says in paragraph 4 that there are pro-life protesters outside the clinic on a daily basis, but it's rare they attend on a Sunday. She says that the pro-choice group are there less often. It seems to me that when we have a surgical day, the pro-life protesters stay for longer. I believe the reason for this is because there's a flow of clients that they want to target. They usually arrive from 8 a.m. and leave around 3 p.m. She goes on in paragraph 7 to explain about one particular protester who she describes as horrible and stern-faced, and that face is intimidating and she feels she revels in clients feeling threatened. And she, Ms. Goncalves, has had to tell her off a few times and even said to her once, "If you keep unsettling women, I will call the police." To which she says the reply was, "Good, then I'm doing my job." And she notes that on days where this woman is present, more women come in and comment about the protesters trying to hand leaflets and telling them not to enter the clinic. I've noted comments from clients including being called mummy. Then paragraph 8, she recalls being told by an interpreter on the 24th of November that protesters had thrown water in the direction of a client, and also reported that a protester had an old camera which was pointed towards the client. So it doesn't matter if a photograph is taken or not. It's the fact that it might be. And she recalls also in paragraph 19 an Irish client, again I mentioned this in opening, who came from overseas. She called to say she was too frightened to walk past the protesters, and therefore they had to go and get her. And Ms. Goncalves says in paragraph 11, "I personally do not think either group should be allowed outside of the clinic. Clients want discretion, not to attract attention." And she goes on to say that there have been occasions when she's gone out to both groups and told them they're upsetting the clients. And the pro-choice protesters have been apologetic, which is asked to tone it down. But the pro-life protesters tell her they are not doing anything wrong and mostly ignore her, and some don't even look at her. And she talks about how infuriating it is, and she also says in the last statement that she spends a lot of her time reassuring clients, and when she can't spend time doing that because the clinic is so busy, it makes her feel bad because she doesn't have the time making such things. So those are the photographs and the witness evidence. Now I then take you to the formal responses to the consultation, and firstly to the Mary Stopes submission. This is, I'll only take to small parts of this.
So how long is it? I think we're quite keen to get onto the grounds of appeal. How long is this going to take?
My Lord, I will stop by 4:30 on these points. I'll deliberately do that because I appreciate them. So, Lord, this is page 45 of the supplemental bundle. It's the Mary Stopes submission to the consultation, which of course forms part of the evidence base the Cabinet considered. And at page 50, they helpfully summarise the activities of the protesters that have been identified. And most of these we have seen before. Then at page 51, there are examples provided from some 13 service users of the effect of the protest, or rather the actions that they had to put up with. And one sees from 51 onwards, I'm not going to read through them obviously, but they are a mixture of being traumatised by seeing the photographs, being uncomfortable about handing rosary beads, the very fact of being approached, being intimidating on a number of occasions, and being shoved leaflets in the face. And then there is a reference on 52, third last para, to the rebooking of appointments, and that delay impacts upon their treatment choices. And then over the page we have further of the impugned activities, including top of page 53, spraying water on clients, and second para, make husbands cry as they're so distraught seeing their wives or partners being harassed. And page 54 is a reference to the counselling that Mary Stopes provide, and of course, as my ladies know, any woman who wishes to have an abortion has to have and is entitled to have non-directive counselling, which is provided by Mary Stopes and other providers. There are suggestions in the evidence that what the appellant activists do is counselling. It's not counselling in that sense, unless one takes it to mean counselling against abortion. There is no sense of non-directive counselling.
Sorry, I haven't really followed that. Could you make that point again?
Well, the point made in paragraph 54 is that
Page 54.
page 54 is that unlike the procedures, we have trained counsellors available. And the point is that women wishing to have a termination are entitled to have counselling. Indeed, they also have to have counselling, which is non-directive as to their options.
Is this done on the same day or a different day?
It can be done by telephone in advance. Or indeed by previous appointment, I think. And then, my lord, at page...
It is correct, is it, that most people visiting the clinic will visit only once or twice?
It's either once or twice. It depends upon many factors. I think it may depend partly on whether it's a medical abortion, which is taking tablets, or a surgical abortion. And it may depend upon the woman's health, but it's either once or twice. I think in the evidence there is a couple of occasions when a service user went on 4 occasions, but that's not the norm. And then at page 62 is a Datix document, which is a record of internally reported incidents, which are ones which have been escalated by Mary Stopes. And that contains a list of 14 such incidents in 2017, again demonstrating the range of the activities that the PSPO seeks to prohibit. My lord, I am conscious of the time, so going then to page 30, please. This is within the submission of the British Pregnancy Advisory Service, and as one sees from page 30, BPAS have been running a back-off campaign since 2014 about putting buffer zones around clinics, and they have acquired a number of reports in relation to various clinics, and as they note in the penultimate paragraph on page 13,
So what are they? Are they a private charity? What are
it's
they?
the British Pregnancy Advisory Service.
What is it?
They're
Are
all
they a charity?
No, they're all. Well, I don't know if they're
NHS
charitable, but they're another provider of abortion services.
Yeah, it's a private provider.
Yes.
Thank you.
And indeed, it is a charity, my lord. One sees that from the first paragraph. It's a reproductive healthcare charity that offers abortion care, contraception, STI testing, miscarriage, mismanagement, and pregnancy counselling to nearly 80,000 women per year.
Yes, thank you.
And they record on page 30, the last, just above terminology, that 159 of those reports refer directly to this clinic. And they then go on to give a snapshot summary of some of those responses from pages 32 on to 35, which again I don't repeat, but again it's all part of the piece. And the judge also had before him some of the individual 159 responses made. And so, for example, if one just goes to page 40, one has a response made by a local resident, in fact, to the Home Office consultation, which I think that was the call for evidence. And that refers to a local resident seeing them grab the arm of clinic users, shouting at users and their partners, and filming residents. And she says, under comment, it's extremely stressful living opposite these protests. It's a regular occurrence seeing protesters standing in the way of clinic users, grabbing their arms and shouting at them. And she goes on, a few lines down, do I comfort the crying women on the street, or do they prefer privacy? Local residents should be able to live a peaceful life and should not have the weight of such things on their shoulders on a daily basis. My lord, the entirety of the 159 reports were all exhibited to Mr. Murphy's statement. They were not physically before the judge because the parties sought to make it manageable for him on a one-day time estimate. But as my lord will have seen, they also all appear in the additional bundle of evidence that I haven't referred to and don't propose to do unless the court wishes me to.
What is that? I mean, that's your extra bundle, which you haven't got permission to put in yet.
No, that's right. I don't propose to go to it.
You don't propose to put it in. Fine.
And then,
It's now past.
yes.
Well, I think tomorrow we would like to start on the grounds of appeal. Is there anything else you feel very compelled to take our attention to now?
Well, can I simply give you the page references within the statutory consultation report?
This is the Murphy.
No, it's the report on the statutory consultation, which resulted in over 2,000 responses with a number of manuscript comments. And that report, just for my Lord's note, is at tab 9. And if I could refer the court to pages 131 to 134, which sets out the main responses to the consultation and also gives a flavour of the narrative responses by those responding. And it's a fact, as one will see from that, that when asked about the extent of the behaviours they'd witnessed, some 470 gave a narrative response. And when asked about the detrimental impact of those, some 1,060 gave a narrative response, which we would submit is very telling. This was a consultation within which people were extremely interested and wished to contribute in a meaningful way. So, Ron, that's all I wish to say. I'm grateful for the opportunity to do that. And of course, tomorrow morning I will start immediately with in the locality.
10:30 tomorrow morning.
No, my colleague got that. Okay, I just wanted to check where
Just one.
Yes,
We're not expecting one.
yes, when they were introducing